My name is Edward Blum. I'm a visiting fellow at the American Enterprise Institute and the founder and director of the Project on Fair Representation. The American Enterprise Institute and the Project on Fair Representation are two separate organizations. My role at AEI is that of a visiting fellow who studies, writes, advocates, and educates Congress and the broader community about issues of law and the intersection of race and ethnicity. The Project on Fair Representation is a legal defense foundation. We provide counsel to individuals and jurisdictions who wish to challenge race-based laws, whether it's in the fields of employment, voting, education, or contracting. The Project on Fair Representation was founded in 2005, and it was founded as an advocacy organization, not a litigation organization. The mission was to persuade and educate Congress and the administration about modernizing the Voting Rights Act. The Voting Rights Act was coming up for reauthorization in 2007. The mission of the Project on Fair Representation was to provide a framework for Congress to update, modernize those provisions that were first passed in 1965. Well, the Project on Fair Representation began as a two-person entity. And like many two-person entities in Washington, the two persons went in different directions. I have respect for my co-founder, who is still active in the movement, but I decided that after some initial meetings with Congress and the administration about the likelihood of making any changes to the Voting Rights Act at its reauthorization, that the only solution would be to challenge this in the courts, and I think that's where our paths diverged. Well, a number of us spent better than 3 or 4 months on Capitol Hill meeting with various congressional leaders, talking about the pitfalls and the problems of the Voting Rights Act, Section 4 and Section 5 specifically. It became very apparent after the first meeting or two that we were not going to be very persuasive to members of Congress. These were not necessarily members of Congress that were Democrats and liberals. We weren't going to be persuasive to anyone, especially Republicans and especially conservatives, who over the years had come to believe that these provisions of the Voting Rights Act actually benefited them in the drawing of their safe Republican districts. We took our campaign from Capitol Hill over to the White House and encountered pretty much the same story. Everyone was polite, everyone was very understanding, but after a few months it became evident that the only way these provisions were ever going to be modified or struck down would be through the courts. The Project on Fair Representation really is a sibling to an organization that I started back in 1992. The story really begins in 1990 when my wife and I were living in a suburb of Houston, and our daughter was accepted to college, and we decided that we no longer wanted to live in suburban Houston, but instead wanted to live closer to the inner city. So we found a townhouse near the Museum District in Houston. I registered to vote in this new district, and when I went to vote in 1990, the Republican Party had not fielded a candidate to run against the incumbent Democrat. This bothered me. I always think that there should be a choice, and not to turn this into a super long story, but 2 years later, I found myself as the Republican nominee running to represent the voters of the 18th Congressional District of Texas, a mostly inner city district, a newly drawn district that had a slight majority African American population. During the campaign, My wife and I went door to door throughout the district, knocking on doors, meeting people, and handing out campaign literature. This was long before the internet and GPS allowed you to pinpoint where people lived. It became apparent that the district that I was running to represent was badly gerrymandered. My wife would be on one side of a garden variety Houston street, and I would be on the other side of this street. One side would be primarily African American, the other side would be primarily Latino. And those streets it became very apparent after just a few weeks of knocking on doors that garden variety Houston streets had been gerrymandered block by block in order to create safe racial districts. For instance, an apartment complex on one side of the street that was primarily African American would be drawn into the 18th Congressional District. An apartment complex on the other side of the street that was primarily Hispanic would be drawn into a different congressional district. This didn't happen just once. This happened dozens and dozens and dozens of times. So that when you looked at the shape of the 18th Congressional District, it ran for many dozens of miles in one direction and many dozens of miles in a different direction, with the goal of harvesting African Americans out of multiracial, multi-ethnic neighborhoods in order to create safe majority-minority districts. This didn't just happen in Houston, this happened in Dallas, it happened in Atlanta, it happened in Charlotte, it happened throughout the Deep South. I didn't attribute my loss to the gerrymandering. I think my loss occurred because it was an overwhelmingly Democrat district, and being young and idealistic, I decided to run anyway. What bothered me about losing was that it wasn't the electoral outcome. It was the fact that these neighborhoods that were multiracial and multi-ethnic were split apart to create a racial outcome. When I went door to door, neighbors were concerned about their neighborhood, their local schools, the issues of crime, whether businesses were coming and going. That's what they were interested in. They weren't interested in the fact that, well, my little neighborhood is connected to another African American neighborhood 75 miles due east of here, and our representative is black. That's not what people cared about. They cared about their neighborhood. So, I guess about 5 or 6 months after the election, I read in the New York Times that a similarly shaped congressional district in North Carolina was under attack for the same kind of racial gerrymandering that I believe had occurred in the state of Texas. I thought that if there was a good case in North Carolina, there very well may be a good case in Texas. Now, I had never sued anyone prior in my life, and knock wood, I had never been sued. I pulled together sort of a ragtag group of volunteers. I found one lawyer in Monroe, Louisiana, who I agreed to pay out of my own pocket a few $1,000s a month to litigate this. And in 1993, we sued the state of Texas, arguing that the congressional plan, as enacted in 1990, was unconstitutional. It was a racial gerrymander that disfigured traditional redistricting principles. That case was styled Bush versus Vera. We went before a 3-judge panel in Houston, and we won. The state of Texas appealed that case to the United States Supreme Court, and lo and behold, the court took it up. We made arguments in 1995, and the case came down in 1996. We won that case in an opinion authored by Justice O'Connor, and my business associates back in Houston recognized that date as the date in which my interest in public finance and investments started to wane, and my interest in litigation and advocacy started to accelerate. While I greatly enjoyed the experience of running for public office, I was also, greatly relieved that it was over. And I think I had had my fill of electoral politics and decided that I would stay involved in public policy, an area in which I've had a long-standing interest. But the ballot box would not be the way I would go about doing this. Because the outcome of Bush versus Vera was so satisfying, and by that I mean Texas had to redraw its congressional districts after Bush v. Vera came down. Texas was unable to do it, but the three-judge panel did. And when you compare the shape of the districts that the three-judge panel drew and compare those to the districts that the state of Texas drew, what happened was that these multiracial neighborhoods were basically put back together. No, they weren't circles and squares and oblongs. They still had some odd shapes here and there. But the block by block harvesting of blacks, whites, and Latinos to be put into different districts that ran many dozens of miles in different directions, that came to an end in the state of Texas with that lawsuit. So what I did, I found that so gratifying that I asked a social scientist, a political scientist that helped with that case, to compile a list of the most racially gerrymandered congressional districts in the country, down to the least racially gerrymandered congressional districts in the country. And that list provided me a roadmap to go and recruit plaintiffs in the states of New York, Virginia, South Carolina, Florida, and other places to apply the opinion that came out of Bush versus Vera and came out of some of the other racial gerrymandering cases to those congressional redistricting plans. I basically took our legal team on the road. We went to New York, sued the state of New York, went to Virginia, South Carolina, and we were successful in all of those states. And all of those states were compelled to redraw some, not all, but some of their districts so that traditional redistricting principles were remedied and put back together.